very first case. The case that we're going to hear is the case of Kieran and Highby versus State of Florida. And if you're ready to proceed, counsel, we're ready for you.
Thank you. Good morning. May it please the court. Michael Ufferman on behalf of the appellant Kieran and Highby. I'd like to reserve 5 minutes of my time for rebuttal.
Very good, sir. Thank you.
I'm hoping to focus my time this morning on the first claim raised in the briefs, but of course I'm able to answer any questions that the court has regarding the remaining claims. The first claim concerns the erroneous forcible felony jury instruction that was given in this case. And I don't think there's any dispute from the parties that it was in fact an erroneous instruction. At the same time, I've acknowledged in my briefs that it was not objected to. So the question is whether or not the erroneous forcible felony instruction amounts to fundamental error. So just a brief background on the forcible felony jury instruction. The instruction itself actually says, do not give if the offense under consideration is an offense for which the defendant is claiming.
And I would like to get into what I think is the tone point.
Okay.
The nut of your argument.
Yes.
First issue. In my view, and you can help me understand why I may not be looking at it correctly, the resolution turns on, let's assume for the sake of conversation that this is I don't know. To me, turns on whether the evidence of the defendants is so weak as to strain credulity, right?
Yes.
And so the question then, in my mind, is the only witness that the state presented who saw these events was Simmons. And he, in most views, might be described as lacking credibility. Am I off base yet?
Not at all, Your Honor.
Okay. And he had kind of said he was the mastermind of their side of the deal and had his own felonious intent, right?
Yes.
And was overly charged. So I'm not sure this falls squarely in the strange credulity, but I'm not sure if the case meets what Judge Casanueva thought got past that.
And Daniels.
And Daniels. So help me out.
Sure. So I guess let me start by saying there's another claim in the briefs regarding JOA. And that's actually the lead claim that Mr. Cordell has in his briefs. The standard for that is very different than, or at least this court's view of the evidence is very different for that than this. And in JOA,
Focused on.
no, I understand, but I guess I say that because
So I want you to, before we get lost.
Sure. But
you can find the question that I have put to you.
well, right, but I think, but Simmons isn't the only evidence you look at in that regard, is why I say that. Because in a JOA claim, you would look at the evidence in the light most favorable to the state, and therefore you would be focused only on Simmons and not on the testimony of my client or the co-defendant. But for this claim, you have to consider all the evidence, including all the evidence the defense presented to support their claim of self-defense. So I submit that everything that the state argues supports their theory that this was not self-defense. The defense had a counter argument to that that was reasonable or debatable, which would mean that we meet the standard under Daniels and Martinez, which is that this is not so extremely weak such that it strains even the most remote bounds of credulity. So let's jump into Simmons. Simmons pled to an attempted robbery, which itself is a forcible felony. The record's clear it wasn't the sudden snatching robbery that we have in Florida. It actually is attempted robbery, which is forcible felony. The judge instructed on that. Simmons admitted that this was going to be a drug sale, and he's the one, he and Melvin, wanted to interrupt that drug sale by giving a bag of fake money, grabbing the marijuana and running. That's obviously why he ended up pleading to attempted robbery. He's the one that began the aggressive conduct in this case. Simmons gave numerous inconsistent statements, and that was highlighted throughout the case. But perhaps most importantly, the other gun in the case was found exactly where Simmons was standing. And that's key. Because when you look at my client's testimony, when you look at Mr. Cordell's testimony, and I'll start with Mr. Cordell. Mr. Cordell said that as my client was being attacked by Melvin, he looked over.
Talk about your client. Sorry to interrupt.
Sure.
We've got a picture of your client within, I think, days of the event, if I'm not mistaken. I didn't see, and the state has argued, and I didn't see any, the vicious beating. There, he has amazing powers of recovery, or there's, the jury kind of heard about that beating, and they resolved the severity of it, and not in the client's favor.
Sure, well,
Help me out with that. I mean, and then this, we're getting into like resolution of fact issues that have already been resolved.
well, or I say it's at least debatable. It may have not been to the extent that it caused injuries that you would see days later. But nevertheless, he said that he was attacked by Melvin. And of course, my client didn't have the gun. He's charged as the principal. But I think the real then act of self-defense occurred when Simmons pulled something shiny or silver out of his waistband. And at the time, to Mr. Cordell's credit, he didn't even know that it was necessarily a gun. He thought it could have been a knife. But once he sees that being pulled out, he has a right to act in self-defense. He doesn't have to wait for that knife to be thrown at or stabbed at Mr. Cordell. He doesn't have to wait for the gun to be fired.
So what are we to make of the 911 call wherein he says he shot them as they were running away?
You know, I think
That's his own words in a recorded call. And as we all know from the case law, you can't use deadly force when someone's running away. If you're shooting them in the back, it doesn't count.
I think, so a couple things about the shooting in the back. The evidence in this case is that the shooting occurred literally in 1.5, 2, 3, 4 seconds at most. The state's firearm expert acknowledged that with the firearm that Mr. Cordell was using, you could fire 10 rounds in 1.5 seconds. Mr. Cordell's testimony was he emptied his clip. We know there was 12 shots fired. So if you take the 10 at 1.5, the additional 2, you're at 2 seconds. So in 2 seconds of shooting someone, if they are in the process of pulling out that gun or knife and aiming it at you, the brain in no way could process.
That's a fair comment. Then how much time would be appropriate? What would you say 1 or 2 seconds isn't enough? Give me the bright line.
I don't know if there is a bright line,
There is no bright line. We both know that.
but it's debatable. So again, that's where it comes down to, does it strain credulity to the remote bounds of credulity? Absolutely not. Defense counsel.
His own word says he shot him in the back. All the ballistic evidence showed that they were all shot towards the door that they were running, the front door they were running out of. So the question really is, we have to review the issue that you've raised for fundamental error because it was not preserved.
Correct.
And the case law tells us that you cannot deprive someone of their defense by giving the wrong instruction.
Correct.
Case law further tells us that defense, if it's weak, the evidence says it's weak, then it's not fundamental error to deprive them of it. So the question is the self-defense theory in this case weak or not? And when you look at his statements on the 911 call and all the ballistic information, these people were all shot running away. Now, whether it happened in 1 second, 2 seconds, 5 seconds, 10 seconds, an hour, I guess that's where we are to talk about that. No one's really left.
But it tests, so we all the time, we have state witnesses who give an inconsistent statement previously and then give a later testimony trial. And then when we view it under the lens of JOA, you view it in the light most favorable to the state. Well, here, Mr. Cordell clearly testified that he shot immediately upon Mr. Simmons pulling the knife or the gun out of his waistband. That was his unrefuted testimony at trial.
There was a gun, right?
Yes. Oh, yes.
Well, I thought it was pretty much universally understood that he was pulling a knife out. Is that?
No, it's not true. So let me be very clear about that. And the record clearly establishes that when law enforcement arrived, so Mr. Simmons was asked about that and he said, oh, I have a gun in the house, but it's in a drawer. But law enforcement found a gun at the scene in the exact spot where Simmons would have been standing during this incident. That is huge. Found a gun in the exact spot where he was standing in this incident. So going back to the ballistics are all in one area. When you read Mr. Cordell's attorney's closing argument, he does a great job on page 1080 of saying, you want to ignore the clear evidence of the shell casings. Obviously, he's moving backwards, he being Mr. Cordell. He's moving backwards while he's firing, following the shapes, following the threat. Why would somebody move backwards if they want to stop someone running away? You move backwards because you're trying to get away from something. So he's saying all of the shell casings were in the same area. They didn't proceed towards someone like you were tracking them. So it supports, again, the defense had, when you go through the closing argument, for every point that the state had trying to say this was not self-defense, the defense had a counter to that. 1, 2, 3 seconds at most. Brain can't process whether or not someone's turned their back in that time frame. He just emptied his clip because he was scared, because he saw Mr. Simmons, at that time, he wasn't sure if it was a gun or a knife, but we now know that it's a gun because the gun was found in the exact spot where he was standing. So just to go down the list, the fact that Mr. Cordell called 911, that's further proof that he knew that something just happened. He doesn't run away. He's telling law enforcement officials that I just had to act in self-defense from these people that, attacked us during a drug deal. So let me compare these facts, which again, we have Mr. Cordell's appeal that his sole issue is you should grant JOA because the state's evidence doesn't even overcome self-defense. And of course, that's pending in this court.
Isn't he also arguing making the same argument that you made on the initial aggressor and accomplice?
Correct. That's true.
And your brief on those sort of referred us to the briefing.
Correct.
In this case, I don't really know what that means, but I did read the briefing in Cordell. And my question for you on those issues is you got the same threshold issue that you got with what we were just talking about, and that is preservation. Am I correct?
I don't, it's confusing. Certainly with the aggressor, it's confusing. If you read pages 886 through 888, this is brought up. And at that time, both defense counsel said that they object to it. The judge then asked this.
Looking at that part of his transcript, I think it was saying, Judge, it will be confusing. I mean, there's no doubt something was raised. It's like you're gonna confuse the jury. Maybe he didn't announce exactly what he was objecting to, but it appears that he had concerns. Maybe that's a better word. So the fact that he did raise this as a concern, is that enough for preservation?
Again, for the aggressor, I think it is. I think that this was specifically, if you read those pages, they are specifically asking about, should we give the aggressor instruction? And the defense both say no. The state then says, I defer to your honor.
What about the fact that the instructions that went back to the jury room didn't include the offending language on either of the instructions?
I don't think that's true for the aggressor. It is true for the accomplice. And I have that right here.
The state can help us out with that, but my reading of the brief was that the sets of offending language were not included in the instructions.
The accomplice definitely was not. And the accomplice is by far the weakest of these three. To be fair, generally aggressor would not be a key issue in a case like this because usually there is a factual dispute and then it would be up to the jury to decide. This case. No, well, not necessarily. I mean, the defense's argument on 886 or 888 was there's no evidence that either defendant was the aggressor. In fact, the undisputed evidence from Mr. Simmons himself is that he's the one that started this, and that's backed up by the fact that he pled to attempted robbery. But going back to, I acknowledge that those instructions are nowhere near as detrimental to my client as forcible felony. Forcible felony told the jury, you cannot find Mr. Highby innocent. You cannot find he acted in self-defense. The instruction literally says, if you find that Mr. Highby, as a principal to Mr. Cordell, was engaged in third-degree felony murder, then he's not justified in use of force. Well, the entire defense in this case is he is justified in use of force. The case law is crystal clear that we expect that the jurors follow the instructions that are given to them. So when the juror reads that instruction, that's the end of the issue. What the judge just told us is he can't rely upon justifiable force if he's engaged in third-degree felony murder. That's exactly why the case law from this court, And every court around the state, all the way up to the Florida Supreme Court, says you don't give that if the offense under consideration is the offense for which the defendant is claiming self-defense. So that's really the issue here.
Your 5-minute rebuttal, just wanted to alert you of that. Feel free to proceed as you see fit.
Thank you. Again, I will take 30 seconds just to go over Daniels real quick. The facts of Daniels involved a man getting in an altercation with a woman. The woman was beat unconscious. When she came to, Mr. Daniels tried to drown her in water. She had numerous injuries. Yet Mr. Daniels testified at trial and said, "Oh, I acted in self-defense. She hit me." And this court said, and I think this reasoning applies directly to the facts of this case. I think the facts of self-defense in this case are much stronger than the facts in Daniels. And nevertheless, in Daniels, this court just said 2 years ago on the merits, the reading of an erroneous instruction on an affirmative defense does not always constitute fundamental error. When determining whether a mistaken instruction constitutes fundamental error, we must consider the effect of the erroneous instruction in the context of the other instructions given, the evidence adduced in the case, and the arguments and trial strategies of counsel. Further, where self-defense is the defendant's primary defense, the evidence cannot be viewed as extremely weak. After a comprehensive review of the record, it is clear that self-defense was Daniel's primary defense. And even if the defense is not particularly strong, it is not, quote, extremely weak, such that it strains even the most remote bounds of credulity. Self-defense in my client's case is not so extremely weak that it strains even the remote bounds of credulity. For every argument the state had, the defense had a counter argument in their closing argument. This was a debatable self-defense case. It may not justify JOA, but it clearly meets the standard for fundamental error for this improper forcible felony jury instruction. My client should get a fair trial where the jury can actually consider his sole defense without being told that, without having a jury being told, you can't consider self-defense. I'll reserve the rest of my time for rebuttal. Thank you.
You have about 3.5 minutes, but I'll give you 4 minutes for rebuttal.
Thank you.
Good morning, Your Honors. Tana Alexander with the Office of the Attorney General here on behalf of the state of Florida, the appellee. May it please the court.
The issue of the morning is whether or not the self-defense, theory of self-defense was extremely weak, because that's what the cases say that we have to do in cases.
Yes, Judge. And I would argue that appellant's self-defense claim is extremely weak because the evidence shows that Simmons and Melvin were running out of the apartment while they were shot.
But you heard his argument, and it's a good one. 1 or 2 seconds is not enough time for the human brain to process a decision of this magnitude.
Yes. However, I do believe that there was more than 1 or 2 seconds, because I don't believe that Simmons and Melvin would have had time to run out that front door or have Simmons or Melvin wind up in the kitchen if it was that quickly. So I don't believe it was that quickly. And
to add one more level.
Yes.
Simmons gave a lot of inconsistent testimony. When I say testimony, he must have given, when he was talking to the police, every single time was something inconsistent. So how do you play that and the overlay with the question that Judge Morris is asking?
I don't want unless. So help us out.
okay. He did give inconsistent statements. In the state, in their closing argument, one of the first things they said is like, you know, he did have inconsistent statements, but there was also evidence that corroborated his statements as well. And additionally, Cordell did not give consistent statements because he told police he was actually there to buy marijuana, not sell marijuana. And when he spoke with police on the night of the incident, he did not mention Highby, nor did he mention Melvin's attack on Highby. So, I mean, Cordell wasn't completely honest either. And again, the state did, through their closing argument, say that Simmons did have some inconsistent statements and the jury was able to weigh his credibility and make a decision on that. As far as the Smith and Wesson, appellate counsel was right. Simmons did state that when law enforcement spoke with him the first time, he did state that there was a gun on the floor in the apartment. He stated it was either on the counter or in a desk. And if there was potential for him to have pulled out a weapon, once that weapon hit the ground and he started running for the apartment door, there's no longer an imminent threat that requires someone to be justified in using deadly force. And in looking at the standards, it's a reasonably cautious and prudent person. A reasonably cautious and prudent person doesn't shoot at someone who's running away from them. And following up,
Let's put it, again, if you look at the whole scenario, you have inconsistent statements throughout. And if in fact a gun was at the scene, and this happened rapid fire, so all of that within seconds, I think you're carving each one well. The gun was on the floor, there was no weapon there. We don't know that.
well,
We
we
don't
look
know
at
that
the,
in the jury, and this goes back to, you want to be able to give the jury the proper instruction for them to weigh all of that, because that's their job. So if you don't give them that, how can we feel confident that the result that they came out is in fact correct?
well, also, if we look at the casings and projectiles that were found in the apartment, as appellate counsel stated, a lot of the projectiles were found in the back bedroom near the bathroom area. And there was some testimony that Cordell could have been backing up, but all the projectiles were found near the front door. So there we have a slit. And
All that evidence is interesting and good, but the standard we have to judge is their theory of self-defense extremely weak? Not that we are persuaded, we're not the jury. We just have to determine whether or not their theory of self-defense was extremely weak. And candidly, on these facts, it's really hard to find them.
yes, and I can understand the court's predicament. But again, if we look at, I'll break it down. If we look at the injuries on each Simmons and Melvin, Simmons shot in the back as he's running out of the apartment. Melvin is shot 6 times, 4 of which bullets are in his back. That is not a position where someone is threatening or creating an imminent threat where someone needs to use deadly force. Going back to Cordell's 911 call, he did say they were running away from me. In his trial testimony, he says, I was just firing at silhouettes and I didn't know what was going on, but he shot his gun 12 times and he hit Simmons and Melvin 8 of those 12 times. So his precision was very accurate.
But he also saw what he thought was a gun being drawn or a knife. And the gun that I've been enlightened and reminded was found in the vicinity of where the incident took place. So again, focusing on extremely weak. It's not like they didn't find a gun. It's not like, all the other facts that we know didn't happen. That's the difficulty. We're not the jury.
I understand. And the jury did hear all that testimony, was able to weigh the credibility of the witnesses and able to make a decision that appellant did not have a valid self-defense
They
claim.
were also given an instruction regarding forcible felony to weigh in. That's the part that concerns me.
Well, also too, the state didn't argue this in closing argument. The instruction was never even touched on in closing argument. It wasn't anything that they harped on.
So what you're instructed, and part of your argument for affirmance on the rest of this case is the jury looked at the written instructions, understood them, and as we presume legally they follow them. So you can't have it both ways on that.
Well,
And also, where the judges usually instruct, Judge Morris and I were former trial judges. We tell the jury all the time what the lawyer says is not evidence. Just listen to the instruction as I instruct you. So the jury listens to that. So the fact that the state didn't say that should be a non-issue.
Well, it is something that the case law does talk about in considering if it's weak, did the state make the argument a closing argument? I've also read in case law, it was an error in affirmative defense, not an element of the crime. I do want to go back to that 911 call because I want to express to the court that it has a higher level of reliability than I think Cordell and Highby's actual testimony. It was a statement that was made immediately after the event, and I would liken it to an excited utterance, which has a higher level
It's
of
a damning piece of evidence, no question about it. No question. But when you put it in the whole of everything, here it is their theory extremely weak?
I think so, because the evidence shows that they were running away from Cordell as he continued to shoot at them. If we look at some of the bullets at the front door, specifically bullet hole number 2, that went through the front door when the door was open. So it went through the front door, through the back door, and into the back of the apartment wall. So that means Cordell was continuing to shoot after Simmons had already run out of that apartment. And Simmons, and that's corroborated by video evidence, because we do see Simmons on video running out of the apartment. And his testimony was that he continued to hear gunshots as he ran out of the apartment. And we also have several projectiles in the kitchen. So while we have projectiles, or casings in the back bedroom, I am going to argue to the court that Cordell came into the kitchen and was still firing at Melvin, because if you look at the evidence in the kitchen, we have bullets going through the cabinets. We have bullets ricocheting off of the appliances. It looks like the shooter had walked around from the living room into the kitchen to continue shooting at Melvin. And his injuries show that he was moving towards the ground. If we look at bullet holes B, C, and D, they show that he was moving towards the ground. We have the trajectory of wound A that went through the folds of his skin that show that he was crouching. These are all very defensive positions, not offensive positions. And Cordell knew exactly where he was shooting because he said it himself. And additionally, I know this isn't probably the biggest key, is I agree with this attack on Melvin with Judge Liberate. I don't think that this attack occurred. And so I want to minimize whatever type of threat was alleged that day. The testimony was that Melvin was hit in the temple, chin, and ear area, and that his, did I say Highby? And his left ear was bleeding. But if we look at video evidence, we don't see Highby walking out of the apartment holding his ear. We don't see any blood coming down from his ear. He doesn't wait for EMS. He doesn't subsequently seek medical attention. And as Judge Liberate mentioned, Detective Lagasse saw him about a week later and didn't notice any injuries to his face. Additionally, the living room would be more disruptive if this attack occurred. The coffee table would be turned over. The water on top of the table might have been turned over if this had actually occurred. So
what's this Melvin was doing in the middle of the living room floor exactly where Simmons was? The forensics suggest he was standing in the ground. Yeah.
If I could offer that explanation to the court, I would. He didn't, unfortunately, give a good explanation of why it wound up on the floor. Correct. And, I think law enforcement probably could have probed him a little bit further to get more details of why it was there. But again, the forensic evidence definitely shows that they were running away. Cordell consciously knew they were running away. That is not what self-defense supports. There needs to be an imminent threat where someone thinks they're going to suffer imminent death or great bodily harm for deadly force to be used. And the evidence does not show that. I'm just going to look here to see if there's any additional evidence I can discuss with the court.
What's your thoughts on the argument that I think is the last argument in the lineup here on the aggressor and accomplice instruction? Your opponent isn't satisfied, I don't think, with the notion that what went back to the jury in writing was sufficient to cure any ills associated with the language in this instance. What do you have to say about that?
First, I do want to say that I do believe those two instructions, the accomplice and the initial aggressor, were preserved. That was an error on my part. I misread appellate counsel's brief as well as the record. So I do just want to say that to the court. Yeah. If we look at the initial aggressor instruction, the state didn't want this instruction, actually. I'm not really sure how it wound up in the jury instructions because the state said we don't want it, but it did wind up there. And it was, I don't think it was something that the jury heavily considered. There was no facts and evidence that either Highby or Cordell were the initial aggressors. And so I don't think it was something that the jury would have considered in their deliberations. And if they did, they didn't really have any facts to utilize that instruction. So I would argue that there was no harm to the appellant in giving that instruction just because.
And what about the accomplice instruction?
Again, I agree with the court, what they said earlier. I think that was more harmful to the state than it was to the defense because the instruction actually applies to Simmons because he was the one who, struck a deal with the state in hopes to gain more favorable treatment. So I think if anything, the jury would be looking at his testimony with more caution. And I think that was more harmful to the state and to the appellant in this case. There is one thing that I did want to add that appellate counsel had argued, and I just wanted to respond to it, is that Simmons pled to a forcible felony. Just because he pled to a forcible felony, he was charged by the state with a forcible felony. That doesn't mean that a forcible felony occurred on the day of the incident. We have to look at the specific facts that occurred that day. And it's quite possible that the jury believed that a forcible felony did not occur.
Ms. Alexander, I know I'm glad you conceded the fact that at least the aggressor and the accomplice had been preserved. And you're still holding firm that for the forcible felony that was not.
Absolutely. Appellate or defense counsel did not make that specific objection that appellate counsel is making today or in their initial brief. I think if the court had heard that specific objection, we may not be here arguing about it, because it probably would have been a little bit more clear to the court any errors in that instruction. So I would argue to the court it should be reviewed for fundamental error because that specific instruction was not preserved for appellate review.
And if it was preserved, you're still taking the position that it was not error in giving that instruction.
No, I do believe it was error in giving the instruction, but I don't believe it was fundamental error based on the arguments that I made to the court and the forensic evidence, the placement of the bullets on Simmons and Melvin, where the casings and projectiles were found, his 911 call, and that the attack on Melvin did occur. And I think that Cordell knew a lot more than what he was letting on during his testimony, just because of the accuracy of his shooting. All right, and if the court doesn't have any more questions for me, I will rely on the merits of my brief and ask for the court to affirm appellant's judgment and sentences. Thank you.
Thank you, Ms. Alexander. I'm going to give you 4 minutes. I don't have to less than 3 minutes and 45 seconds. Okay.
Thank you, Your Honor. So let me just clarify a couple of points. On page, there's drafts of jury instructions, and I think the final jury instructions in the record. I think the final instructions are on page 187, and that does show, as state argued, that the accomplice instruction was not in the written instructions, but the aggressor instruction is there. Another point I want to make, there's been discussion about whether or not Simmons was shot. That's irrelevant to my client's case because my client wasn't charged with any crime relating to Simmons. My client is only charged with third-degree felony murder as it relates to Melvin. The state's offered a number of beliefs, speculations, theories. I understand that. The defense did the same at trial. But at the end of the day, for every belief, theory, argument that the state had, whether today or at trial, the defense had a countervailing argument that supported self-defense. That's why.
And that's why I asked Ms. Alexander my last question. And I'm glad she responded the way she did. She agreed that it was error to give the forcible felony. However, she takes a position that it's not fundamental. So for our purposes of analysis, is the fundamental error analysis under all of these facts that are before us. I just want to make sure that that's clear.
Yes, that is correct. But again, from Daniels, we know the question to be asked, 2 questions. Is self-defense his only defense? No question. Just as it was in Daniels, it is here. And then the only other question is it so extremely weak that it strains credulity? We're just not there. And the last thing I wanted to go over, the 911 call clearly has some damaging aspects to it, but it also has some favorable aspects to it. And this is page 338. Again, this is in the immediate excitement of him just emptying his clip. And Mr. Cordell says this: I had to shoot 2 people that came at me with, and then I don't know what just happened, but clearly he's saying I had to shoot 2 people who came at me. He goes on to say on the next page, 339, they are probably dead. They're on the ground, not moving. I just pulled the trigger. I didn't stop firing. I was scared for my life. I didn't know what to do. He punched. He tried to punch me and stuff. He came at me with a knife. I didn't know what to do. And then when I was shooting, then he says, after they ran away, they saw me with a gun and started I shot at them and they ran away. That can be read both ways. And the last statement is, I shot at them and they ran away. So he's not totally clear. It's understandable. He's just emptied a clip.
We know that officer shootings, officers aren't even interviewed for 48 hours because their mind's not thinking clearly in the excitement of the event. But even in the excitement of the event, he's saying they came at me, I shot at them, and they ran away. So the state can pull out one or two tidbits of that, but the defense can pull out one or two tidbits as well. And then, of course, Mr. Cordell completely clarified that at trial and said, I shot them as they were coming at me. So again, it's debatable. It's a much harder issue if I'm going to my claim 2 and saying, oh, this
And
is.
it's debatable gets you passed.
Yes.
So we reduced it to those terms.
Yeah, you're correct, Your Honor. I'm using debatable as something that's the opposite of extremely weak that strains the bounds of credulity. So my client's not asking, I understand there's an alternative claim with JOA. That's a much harder road for my client to travel. But for this claim, my client didn't get a fair trial because there was an erroneous jury instruction as conceded by the state. And I would simply ask this court to reverse, to give my client a fair trial so the jury can properly consider his claim of self-defense. Thank you.
Thank you. You both really did a great job arguing this very interesting case. Thank you both so much.